appellate advocate. Stephanie is a experienced appellate advocate who's been to the Sixth Circuit, to the Court of Appeals, to the Supreme Court here in Michigan. And like our mission of being bipartisan, Stephanie has represented both plaintiffs and defendants in all manner of the trial court and appellate proceedings. She helps lead the section's amicus efforts, working with our vice chair, Tim Diemer, and she is a valuable member of the section leadership. Frankly, ever since the first day of law school, I knew she was going to come out on top on law school, and she certainly continued that skyrocketing career through her hard work. And she is an amazing, amazing woman and an amazing lawyer. So with that, I will turn the reins over to this program to our fabulous moderator, Stephanie Arndt.
Thank you so much, Chad. Very generous of you, as always. Welcome, everyone. We have a very kind of packed agenda today to get through in an hour, but the beauty of it is we're all very punctual, direct, and pointed people. So I don't want the packed nature of our topics to keep you all from asking questions. If you have any questions at all, please pop them in the chat. That is my one job, and I hope I will execute it well to monitor that and make sure that we get the questions asked. The goal is to do it in a kind of as the topic is unfolding format, but if at any time, you think of something later and you want to pop it in the chat, we can always do question and answer at the end as well. But we do want to have this as interactive as possible. So please feel free to ask away. And with that, Tim and Eric will kind of share with you the agenda that we have about things that have come out of the court recently and about some really interesting cases that we have coming up for oral argument, especially the March calendar. If you are not one to watch oral argument on the court's live stream, I highly suggest that March 1st and March 2nd, you block off your calendar and you make that a point, because there are some definite significant changes that are going to come out in our jurisprudence. And sometimes the questions are just as important as the opinions. So with that, I will turn to Tim and Eric.
Hey, thanks everybody. My name is Tim Diemer. We have a little bit of a mix for everybody today. We've got some med mal lawyers, no fault lawyers, general practitioners, premises liability lawyers, a little bit of everything. So instead of getting into the weeds on some of the technical nuances of med mal litigation or no fault, we'll try to speak in general terms of what's happened in the past Supreme Court term and what we think is going to be coming in this current term. And we'll also touch on a couple of recent Court of Appeals decisions of major significance that are going to make their way to the Supreme Court at some point. Thematically, we're going to focus on cases that, in our view, show that the current Michigan Supreme Court is exhibiting a preference for adjudication of meritorious claims on the merits, as opposed to dismissing cases or finding ways not to decide them on technical or procedural grounds. And then some of the other kind of themes that we're seeing out of the case that the Supreme Court is expressing an interest in. And on that first topic, for those of you who've done medical malpractice litigation, for the previous 10 to 15 years, there was, rightly or wrongly, in the Michigan Supreme Court, pretty frequent instances where a technical shortcoming of the plaintiff or the plaintiff's expert witness could result in a dismissal of the case without letting the case get to discovery or a jury or any sort of assessment of the merits. And sometimes those technical defaults would be a defective affidavit of merit that a medical malpractice plaintiff must attach to the complaint in order to pursue a medical malpractice claim, or a notice of intent to sue that must be served on the medical care provider in advance of filing suit. And there were repeated cases where a plaintiff's attorney carelessly or recklessly failed to comply with these statutory requirements, only to find the case dismissed. Currently pending in the Supreme Court are a number of medical malpractice cases that have not been decided yet. So we're kind of guessing a little bit about what the ultimate outcome is going to be, but the Supreme Court's not likely to take a case unless it intends to issue a new policy or a new rule of some sort. So we're going to kind of project what we think the Supreme Court's going to do with these cases. So I'll start with two medical malpractice cases the Michigan Supreme Court has granted leave on. They both have been argued. We don't have a decision yet, but we think we know where these cases might ultimately go. The first one is a case called Amdt versus Katranji. In this case, the plaintiff's attorney secured an affidavit of merit to support the theory of medical malpractice against the doctor. But when the plaintiff's attorney filed the complaint, there was a clerical error, and the affidavit of merit was not actually attached. And the result, through the Court of Appeals, some of the theories of negligence were allowed to go forward. Some were not, based on when the alleged malpractice occurred. And the Supreme Court has taken up the case to decide a couple of issues. The first one is, does a complaint without an affidavit of merit toll the statute of limitations when it's an innocent mistake? In that case, the plaintiff filed the complaint without the affidavit of merit, did not discover the mistake until a couple months had passed. And that couple months of time would make the allegations either timely or untimely. So the Supreme Court is going to look at the question of whether a complaint without affidavit of merit tolls the statute of limitation or not. And then secondly, again, question of whether we're going to discuss the merits or the procedural defaults is in the instance where a complaint is dismissed for not attaching the affidavit of merit. Should the dismissal be with prejudice or without prejudice? Though under the prior cases, a situation like this, the plaintiff would find the claims dismissed, no right to pursue discovery, no right to get in front of a jury. The fact the Supreme Court has taken this issue up leads us to believe that they're more likely going to take a pro decision on the merits approach to situations like this, as opposed to strict adherence to the technical requirements of the statute as a grounds to dismiss the case. The other case that fits this theme in the med-mal context is Kostadinowski versus Harrington. This is another procedural requirement of the medical malpractice statutes. The plaintiff must file a notice of intent to sue the medical provider. And in this case, the plaintiff submitted a notice of intent to sue that listed 6 specific theories on which she believed the defendant was negligent. The plaintiff then filed an affidavit of merit, again, mirroring these same 6 theories of medical negligence against the defendant. During the course of discovery, the plaintiff identified a 7th basis on which to hold the defendant negligent, and ultimately abandoned the 6 that were originally pursued in the notice of intent affidavit of merit. The plaintiff claims that there would have been no way to uncover this 7th theory of negligence except through the course of discovery. And the question in that case is whether a plaintiff should be allowed to retroactively amend a notice of intent affidavit of merit and make that 7th theory of negligence timely through a retroactive amendment. Again, in the 5-10 years ago, the answer would have been no, and you're stuck with the notice of intent as originally filed. The affidavit of merit is originally filed. You can't go back and add new things to it. But the Supreme Court has expressed a willingness to at least consider the question of whether, in a case like this, where there was no good faith way, according to the plaintiff, to identify that 7th theory of negligence, whether we should allow the plaintiff to amend the notice of intent affidavit of merit complaint retroactively to pursue that claim. So again, this seems to represent a shift, again, away from technical procedural defaults and strict adherence with these statutes to maybe allow a party who, again, forgot to attach the affidavit of merit that was secured or discovered a new theory of negligence that they'd like to pursue. They might be able to pursue those claims anyway, despite less than a perfect compliance with the medical practice statutes. I believe, Eric, I think we're going to turn it over to you to discuss some more about now.
Yeah, thanks. Hi, my name is Eric Kahn. I'm a partner here at Jacobs and Diemer as well. Picking up where Tim left off in terms of adjudication on the merits, we have the Stokes versus Swafford case, another medical malpractice case that deals with one of the fuzzier issues that's always been out there in medical malpractice, which is what specialty is required for an expert. In this particular case, There was an interpretation of a CT scan of the cranium, and the plaintiff's expert was an expert in neuroradiology. However, the defendant doctor was a specialist in diagnostic radiology. So the determination was in the trial court that the one most relevant specialty would have been what the defendant doctor's specialty was, diagnostic radiology, as opposed to neuroradiology. The plaintiff appealed on application, was granted by the Michigan Court of Appeals, and the trial court's decision was affirmed. In affirming the result, the Court of Appeals found that even though the expert, the plaintiff's expert, was a subspecialty in this particular case of neuroradiology, the expert himself, the doctor that was providing the care, was a diagnostic radiologist, and therefore his specialty prevailed. The Michigan Supreme Court ordered a mini oral argument on application to address Woodard, which is the seminal case that determines what the specialty must be in terms of expertise. So we'll see what is coming down the road there. But again, as Tim noted, with regard to the Michigan Supreme Court taking up a case, usually that portends that there's going to be a change in the law. In this particular instance, we can assume that is going to take place as well, and that in this, at least in this context, a subspecialty where the radiology, the neuroradiologist was a subspecialty, is going to be allowed. Another case where we have a merits-based decision in a technicality of sorts is the Danhoff versus Fahim case, which deals with the admissibility of expert standard of care testimony. In that particular case, we had a plaintiff's expert who was going to be struck, or was it was questionable whether or not he should be able to testify, because his opinions themselves were based upon information where there was no medical literature to back it up. And based upon that, the defendants filed the challenge. The trial court upheld the challenge and found that the plaintiff's expert could not testify because of the lack of medical literature. Now, in this particular case, the trial court took a good step, in my opinion, and suggested on the record that if the plaintiff could provide some medical literature, that a recon would be considered. The plaintiff did file a motion for reconsideration. The affidavit of the expert was supplemented, but the trial court did not feel it went far enough, and therefore the reconsideration was denied. The Court of Appeals affirmed, and we'll talk about the concurrence in a second, but the affirming of the trial court basically came down to whether or not the existence or lack thereof of medical literature was dispositive in the case. And it's never been the case where it's been dispositive, but it's a strong factor that goes to the reliability of the opinions. And in this particular case, the Court of Appeals found, as did the trial court, that there was no support for the opinions that the plaintiff's expert was providing. There is a concurring opinion by Judge Doug Servito in the Shapiro in the case, and in that particular case, he indicated that he was bound by stare decisis, but there's a question as to whether or not, in his mind, Daubert applies to a standard of care expert as opposed to a causation expert. And the court, or the Michigan Supreme Court, has taken that case up as well on a mini oral argument on application. Another case, it's a med-mal case. The Supreme Court ultimately didn't issue an opinion in this case, but it's an important point, because it kind of, if we're playing connect the dots with some of these cases to determine what's going to happen in the future, it's important. The Legion London versus Surgical Institute of Michigan case, in that particular case, there was an affidavit of merit that was filed, and there was an amendment, and the amendment actually was brought by a different expert. So a different expert then provided the original affidavit of merit. The Court of Appeals found that it was okay, that the term amendment is ambiguous as to whether or not it needs to be the same expert as the original affidavit of merit or not. The Michigan Supreme Court originally took that up on a MOA as well, but then denied leave for lack of need to review in that circumstance as well. And what we have here, the cases that I've discussed and that Tim has discussed, is an overarching theme that it appears, and we'll talk about access to justice a little bit later, but it appears that we're trying to open the courtroom doors more to allow a meritorious determination of cases, as opposed to dismissing cases either with or without prejudice on the basis of a technicality that really should not keep litigants from pursuing their claims. The next theme that we've identified that we want to bring to your attention is a return to the common law. And this is a case that Tim actually handled. I'll let him talk about it. It's McMaster versus DTE. Tim, you want to talk about McMaster?
Sure, I'd be happy to, unless Stephanie, are there any questions or comments that are popping up that we should address?
Not yet. We had one person ask if they can get a case list, and as you responded to their question, that is something that we can provide if you're interested. Just send him an email at the conclusion of the presentation, and he'll be able to get that. Also, the Supreme Court's website does contain all of the historical information about the cases, both the ones that are pending now, as well as synopses of the issues that they've requested briefing. So you can always find both the cases and the briefs, which are always very interesting, especially the amicus on the court's website. So no, I think we're in a good spot right now if you want to talk about McMaster.
Sure, thank you. Yeah, the Supreme Court's website is very user-friendly. And in prepping for today, I mean, that's where I went, pulled the orders granting leave, Court of Appeals opinion, the parties' briefs. It really gives you all the information you might need. So yeah, as Eric and Stephanie noted, the second theme is a return to the common law. The McMaster versus DTE case that was my case, and I'll get into the facts in a minute. But you know, during my 20-year career, I've attended seminars out of state for DRI and other kind of national groups. And when it came time to discuss Michigan law, what's going on in Michigan as our state update, the theme was frequently that our Supreme Court much prefers to simply enforce and interpret a statute as opposed to wading into the common law. Again, that's how my career had been for the first maybe 18 years. And we are starting to see a shift away from just statutory interpretation and wading more into common law issues. And McMaster versus DTE fits that theme, I think, to a T. That case, again, the facts are highly specific, and the chances of you having a case like McMaster are very, very slim because it doesn't occur all that often. But the bigger picture principles from that case are important, and I think you will need to use those in your legal career. And McMaster was a trucking injury case. A truck driver picked up a load of scrap metal, drove across the state to dump it at a scrap yard. He opened up the back of his truck and scrap fell out and hurt him. And the question was whether the party that created the scrap metal during construction owed the plaintiff a duty of care, and whether the entity that created the scrap could be held liable. So there were two different bases on which the Court of Appeals and Supreme Court could have decided this case on the question of duty of the shipper. So the shipper in this case was DTE. It created the scrap and then shipped the scrap to a scrap yard. And the Michigan legislature adopted federal motor carrier regulations with a full effect of a statute that places the duty to secure cargo in this instance on the truck driver, not on the shipper, but on the truck driver. So that would be a statutory basis for absolving the shipper, such as DTE in this case, of legal liability, saying, hey, the statute says it's the driver's responsibility, no one else's. You can't hold the shipper of cargo liable. The other way to approach the case was under the common law. And there's a common law rule that had been adopted by almost every state in the country, except for Michigan, which had not even addressed the question of whether this common law rule applied. Again, because the circumstances of this case are highly specific and the odds of it happening again are pretty slim. The Michigan Supreme Court never addressed whether to adopt this common law principle called the Savage Rule. So in this case, based on my, at the time, 18, 19 years of legal practice, I started with the statutory analysis. Issue number one, Supreme Court, you should adopt and interpret the statute that says the truck driver, the hauler, has got the exclusive obligation to secure the cargo. And if he's hurt, he can't point the finger at the shipper or anybody else. And then issue number two was asking the court, well, if you're not going to apply the statute, we would ask you to adopt the Savage Rule. It's a common law doctrine. It gets into foreseeability, policy of preventing future harm, all these things we learned about in law school, but haven't had to use a whole lot. And to my surprise, the Supreme Court didn't reject the statute, just said, we don't think that controls here. We're going to weigh in on the common law, and we're going to adopt the Savage Law in Michigan as controlling legal authority. So again, I don't think you're going to be citing the Savage Rule in too many cases here in Michigan, but this does represent that, especially for an appellate attorney, it's not just interpret the statute, this is the plain language and apply it, but you're now in a position to argue common law principles, which wade more into policy considerations. So if you've got a common law rule you're unhappy with, we're going to get to some later, you can now not just say, well, the legislature controls. No, you, Court of Appeals, you Michigan Supreme Court, you're free to weigh in on what you think would be the best policy for Michigan residents. And McMaster, again, I don't think you're going to be relying on that case for the specific principle there all that often, but going forward, feel free to weigh into common law public policy making arguments, because I think they're more likely to be receptive than they had been in the past.
Absolutely. And the important thing to remember when you're making those arguments, I think, Tim, is to make sure that you start making those creative arguments in the trial court so that you do have your record preserved and you give a bunch of different judges the opportunity as it moves up through the pipelines to look at that issue and weigh in on that issue and make sure that it's always preserved for the Supreme Court's review. Eric did discuss, one issue that has really been important to the Supreme Court. It was a massive importance to Justice McCormick when she was on the court as well, is access to justice and making sure that all Michiganders have the right to get in front of the courts and be heard and be represented in a meaningful way for consideration by the courts. And one way that we are definitely seeing that now is, as Eric and Tim talked about, was this shift in the court to less summary dispositions being granted, a broader look at the law, a less focused analysis on technicality. I mean, I know when I started, APSI was a big deal, Roberts versus Macosta, very textualist approach, very strict approach. And now we are definitely seeing a broader view of things. One area that is a to be determined, but definitely has a lot of attention of people is what is going to happen in Michigan premise law liability in 2023 and looking forward. We had a sneak peek at some changes when the Supreme Court issued their decision in Livings that dealt with special aspects and employees confronted with significant snow and ice accumulations. And in March, in addition to the Andre decision, which is on our list today too, we also have a series of many oral arguments that have been granted as it relates to premise liability. We have the Al Said versus F&E oil case, which dealt with a snowy parking lot while it's still snowing. And there the court has granted leave on specific issues related to the development of Michigan's special aspects doctrine, and kind of asked everyone to offer their thoughts on Lugo versus Ameritech and whether that premise is consistent with how Michigan premise liability should be. There's been several amicus briefs that have been filed in that case on both plaintiff and defense. Very interesting discussion there developing as it relates to duty, comparative fault, premise liability, and how those statutory and common law ideas are going to merge together and how they impact on summary disposition motions. Similarly, at the same time that Al Said is being argued, it's been consolidated with a case called Pinsky versus Kroger. Now, interestingly, while the two cases have been consolidated together for purposes of the mini oral argument, very different facts. The Pinsky decision involved a situation that occurred inside the Kroger involving a woman who tripped across wires that were being, well, not wires, that sounds bad. There was a cable across a grocery checkout area that had kind of like a formula baby food stand or something in the middle of it. And the patron was trying quickly to get out of the store and did not see the cable. Testified apparently, according to some of the filings, that just wasn't looking or didn't see it for whatever reason. Not that it wasn't visible, but didn't see it and was injured pretty significantly. And so there, the court joined the cases, but the questions that the court requested briefing on were slightly different and more focused on the open and obvious doctrine as a whole, possible involvement of restatements, which is kind of, what Tim was talking about with this whole reach to common law. And then we had, there's also another case, Becker versus Enterprise, which kind of an even broader grant app, and still looking at the whole, premise liability, duty, comparative fault. So, while obviously we haven't even had the ability to do oral argument yet, that's scheduled for March 2nd. Very interesting to see in the future what's going to happen there and how that will impact our motion work. And honestly, probably a lot of our discovery work moving forward, and then how that will translate into impacting the dockets that the trial courts have as it relates to the number of cases that are going to be proceeding to trial. So I think, Tim, you were going to talk about Doe versus GM and kind of that access to court issue as well.
Sure, I'd be happy to. Obviously, the premises case, I mean, that's huge, open and obvious. It's been such a central feature of Michigan law for many years. Everyone's going to have their eyes on that. Doe versus General Motors is a little bit of a sleeper case, sleeper opinion. That involves, again, another issue that you're probably not going to address all that often in your career, the exclusive remedy provision of the Workers' Compensation Act. And one of the statutory exceptions is in the case of an intentional tort, an injured employee can sue his or her employer. If it's negligence, gross negligence, reckless, your sole and exclusive remedy is in the workers' compensation system. Obviously, intentional tort means intentional tort. It's traditionally been understood as an employee assault on another employee, something like that, where the defendant actually intended to hurt the other party, or knew the other party was going to step into some dangerous situation and simply didn't care. It was more than content to let the fellow employee get hurt. It's a really, really high standard. Intentional tort means intentional tort, meaning incompetence, OSHA violations left and right. That's not an intentional tort. So Doe versus General Motors is an intentional tort exception case to the exclusive remedy provision, where the plaintiff was horrifically hurt by a malfunctioning piece of machinery at a General Motors facility. The plaintiff was not, punched by an employee or tripped by an employee or anything like that. It was the employer had a press that had been I think it was press, had been malfunctioning, had malfunctioned in the past, and the plaintiff was hurt by it. Again, in maybe the 10, 15 years ago, that's egregious negligence, that's reckless, that's irresponsible, the allegations if true. And the case would have been properly dismissed on C8 motion based on the pleadings. No amount of discovery is going to show that the manager at the GM facility actually intended to hurt the plaintiff. That's not going to fly. Well, the Supreme Court in Dover General Motors is not weighing in on whether the intentional tort exception was proven or is valid or anything of the sort. But the issue is limited to whether the plaintiff should have been at least allowed to pursue discovery to make his case. The case was dismissed on C8 motion in lieu of an answer, no depths, no anything. And the Supreme Court has again granted, I think it was leave or a mini oral argument, which happened last month on the question of whether a plaintiff facing such a high, almost insurmountable burden still at least gets a chance to do some deposition. Maybe the depositions would show that the manager had an axe to grind with the plaintiff, or the manager witnessed 5 or 6 other employees get hurt in much the same way. I mean, these are all purely hypothetical questions, probably not going to be proven. The plaintiff's attorney was pretty candid at the Supreme Court argument, so I might not prove my case, but I should at least be given the opportunity to do so. So the reason I think Dover General Motors is a sleeper opinion of great importance is because if that cause of action for intentional tort is not ripe for dismissal on the pleadings alone, then very few causes of action are. They're going to have to literally be claims that no amount of factual support could ever justify this relief because this relief is not warranted under Michigan law, something along those lines, or it's an invalid cause of action. But here, for the plaintiff to prove an intentional tort is going to require a whole lot of favorable discovery to come in. But even there, the Supreme Court is deciding the question of whether the plaintiff should be allowed to at least make his case. And maybe they ultimately would say the answer is no. But again, the court granted leave and was interested in the issue. We think probably to change the law. We could be wrong on that. But if the court does say that the plaintiff in Dover General Motors gets his discovery, then I think from a defense perspective, you're going to have a much tougher time getting a case dismissed on a C8 basis if that's ultimately the way the Supreme Court goes in Doe.
So thus far, Tim's been talking to you a lot about cases that kind of portend what the Supreme Court might be doing going forward, but something that maybe doesn't arise in everyday practice. I have a case, Price versus Austin, that I think you'll probably see fairly regularly in your everyday practice. And Price versus Austin was a sudden emergency case where a truck driver testified at his deposition that he had a coughing fit, blacked out, crossed the center line, and a motor vehicle accident occurred. The testimony of the truck driver was unrebutted, and the medical records confirms or seem to confirm that he had indeed blacked out or suffered from some type of medical emergency that led to him losing consciousness crossing the center line. The defendant filed a motion for summary disposition saying essentially that because the driver's testimony was unrebutted, he was entitled to summary disposition because there was no indication that he had breached any duty. The case was dismissed in the trial court. Court of Appeals affirmed with one judge dissenting. That was Judge Glacier, who said, yeah, but hold on a second here. We have a situation where credibility is always an issue, and there's a possibility a jury could hear the truck driver's story and say, I don't buy it, and because I don't buy it, I'm going to find in favor of the plaintiff. There was an application to the Michigan Supreme Court in light of Judge Glacier's dissent, which I'm sure weighed in on the decision-making process to make the application in the first place. And the Michigan Supreme Court reversed for the reasons stated by Judge Glacier. And this is an important case in my mind because when I was a young attorney and coming through the ranks, I would get the 2040 policies, and oftentimes it's husband against wife, for example. and nobody wants to testify against the other. So you do have situations where evidence was unrebutted, and a lot of times under kind of old regimes, those cases would be dismissed routinely. We now have a situation where in light of the push to open the courtroom doors as wide as we possibly can to allow for the adjudication of claims, where credibility, even when evidence and testimony is unrebutted, can be enough for there to exist a question of fact moving forward for trial. Two cases that deal with access to justice, but in a different way. Champaign versus Amdt being the first one, and Filizzetti versus Gwynn Area Public Schools is the other one. Those both deal with the Governmental Tort Liability Act. Champaign, I'm sorry, was a highway defect case. Filizzetti was a building maintenance building defect case. And in Champaign, the plaintiff filed a complaint in the Court of Claims, as you do when you file suit against Amdt or the state of Michigan, but didn't also file a notice of intent to file a claim. And the case was dismissed for failure to file the notice of intent to file a claim by the Court of Claims. That ruling was upheld by the Court of Appeals. The Michigan Supreme Court reversed and found that the filing of a complaint is sufficient for also filing a notice of intent to file a claim. So I struggled with Champaign. We could have put it in the first topic we talked about, which is procedural defects and kind of brushing those aside to get to merits-based decisions. But I think this also provides an access to courts as well, which is ultimately why I put it here, because it's a loosening of the stringent GTLA requirements and what those states in the Governmental Tort Liability Act. We're loosening the standards that are applied there, and therefore we're allowing more claimants to come forward and proceed towards trial. In Filizzetti, this was a case where there were unattached, large, like 350 pound panels in a gymnasium, and the question was whether or not those were fixtures. They were, at the time of the incident, not secured to a wall they were leaning against. They fell and crushed a young child, and suit was filed. The case was dismissed, and the Court of Appeals, I believe in that case, although I don't remember for sure, affirmed the dismissal. The Michigan Supreme Court reversed after a MOA and said, no, these particular panels were a fixture on the basis of the fact that they were large and they were intended to be affixed to the building. They just weren't at this particular point in time. Therefore, there was a duty to remedy that situation and reaffix them, and the failure to do so was found to be potentially, no finding of fact in the Supreme Court, but potentially to be negligence, but the case was allowed to continue. Again, kind of a loosening of the historic idea of what a building defect case is against the state or against the municipality in this particular instance, and allowed the matter to go forward. I don't know if we have any questions or not, Stephanie, at this point in time.
I don't. We're a very quiet group, so I'm sure everyone's busy eating their lunches, but we hope to chime in. We hope you will chime in. One thing, Eric, that I thought about while you were talking about Price versus Austin, which is something that's kind of, we've been seeing a lot, is that was an order and not an opinion. And, you know, I've had a lot of people ask me, you know, why are we getting more orders than opinions? And, you know, what happened, you know, do they have the same impact and do they have the same precedential effect? And, you know, since we're going to have a little bit of time here, I didn't know if you guys wanted to weigh in on that and offer some discussion, you know, as far as from a practical perspective, when people are citing and discussing these opinions in in court filings in the trial court level.
Well, yeah,
Oh,
I'm sorry,
Go ahead, Tim.
I was gonna say, yeah, the general rule, if an order of the Supreme Court contains reasoning and rationale and an end result that can be applied and followed, then yes, it's got the same force and effect as an opinion. For a longest time, the Supreme Court would grant oral argument on the application, which basically is, should we grant the application or not? As opposed to simply saying, yes, we're granting leave and we're going to issue a decision. The mini oral argument on the application gives the court some additional options. For the rule used to be, I'm pretty sure it's the same rule now, that if an application for leave to appeal was filed and there was no oral argument on the application, no grant of leave, it took 5 of the 7 justices to issue peremptory relief in a peremptory order. If argument is granted on the application, that standard went from 5 of the 7 to 4 of the 7. So by having a mini oral argument, it gives the court the additional option of getting peremptory relief with only 4 votes as opposed to 5. That was the rule 10 years ago. I'm pretty sure it's the same now. It hasn't been changed, so don't quote me for sure on that. But that's why in the past there was more, you kept getting these mini oral arguments. And I was joking maybe 2 years ago. These are the kinds of things that appellate lawyers joke about. I was talking with Mark Rizzato. Hey, Mark, isn't it hilarious? When's the last time you saw the Supreme Court actually grant leave as opposed to grant the MOA? And sure enough, I was the appellee in McMaster versus DTE. Maybe 2 weeks after he and I had that conversation, the Supreme Court granted a full grant. It was a full grant of leave, not a MOA on the application. And then I've noticed since then there have been. It used to be like 90%. It seemed like we're MOAs, and every once in a while you get a grant. And now it seems to be more even between the two. That's just anecdotally, that's been my experience from looking through these cases.
And I'll add to that. Filizzetti as well was an order. It was not a written opinion. And the way we've been presenting in this case, or in this seminar, is the fact that even though they are orders, we do treat them as if they're precedentially binding, because they do provide that type of analysis. Now, for the benefit of today as well, they also give us an insight as to what the court is doing and what direction they're going, which is helpful in knowing where jurisprudence is headed, not only in the short term, but I think the long term as well, at least while we have some stability in the court like we've had over the last couple of years.
Fantastic. And I think one case where there was a full leave granted that we're going to talk about next is the Andrew decision.
Yeah, so that's one that everybody that practices no fault law is super excited about, because we have the Court of Appeals decision. We're not sure exactly what the Michigan Supreme Court's going to do, but hopefully some of the tea leaves that we're trying to spread out on the table here will help people come to an understanding as to what it will mean. Andari, really quickly, is a case that also has a companion. I think it's Kruger is the name of that case, where there's a challenge to the retroactivity and constitutionality of the most recent no fault reforms that happened. I think it was in 2019. The Andari plaintiff is challenging the family provided attendant care regulations and limitations that were added to the reforms. And then the Kroger is challenging the limits on full-time inpatient rehabilitation center care for somebody that had a traumatic brain injury, based upon the Medicare schedules that were put in place. And the trial courts both issued injunctive relief, staying it, that went on appeal. The Court of Appeals found 2 things. One, generally statutes are not applied retroactively, but prospectively, unless the legislature says something explicit to the contrary. That's boring stuff, so I'm going to skip over that. Basically, they found that there wasn't anything explicit in the reform, so who cares about that? The fun part about the case is that the Court of Appeals said, even if there was an intent by the legislature to apply them retroactively, such an application would be a violation of the contracts clause in the Michigan Constitution, basically saying that prior to the reforms, the people that were hurt in a motor vehicle accident and relied upon unlimited PIP, specifically medical, in a no-fault case, had that expectation. And if the courts were to apply it retroactively, the reforms retroactively, that would upset their rights to the contract that they bargained for. And the court found that to be too much of an impediment to their contract, and therefore found that even if the statute was intended by the legislature to apply retroactively, they were not going to do it, as it would be unconstitutional. There are a number of cases that are pending up and down, not surprisingly, because no fault is as prevalent as it is at this point in time. One that was just held in abeyance, Her versus ACIA, that was just recently in January. I think it was January 31st, is another case that's pending. So we will have a number of cases that will come at some point, likely this year, that will address this particular issue and will have a significant impact on what is the largest portion of any litigators, or most litigators, pending caseload, which would be PIP and no fault in general. And I know Tim wants to talk about Vasquez and Juma.
Yeah, those are two Court of Appeals recent decisions. I would piggyback on the no fault reform issue with one other case that came out last year. It was MOA, then resulted in a unanimous opinion, Mecosta Medical Center versus Metropolitan Group Property and Casualty. Another no fault case. This is going to take a little bit of context. So until the Michigan Supreme Court's decision in Covenant Healthcare, when a person was injured in an automobile accident, that person could file his or her own lawsuit against the insurer for PIP benefits. But a medical care provider could also do so. So someone provides care to an injured party. That party used to be able to file a direct action against the insurance company. Covenant came out and said, no, the statute does not allow direct actions. A medical care provider must get an assignment of the rights to insurance benefits in order to pursue a lawsuit. So in the direct action days, again, pre-Covenant, the rule used to be that if a medical, sometimes you'll have an injured party and 10 medical providers, and you'd have 11 different lawsuits. The rule used to be if a medical provider, I'm trying to take a step back. If the injured party files a lawsuit and a lawsuit is dismissed or the jury rejects the theory or something like that, well, the medical provider was barred under res judicata and collateral estoppel principles from filing their own lawsuit. So it was kind of a race to see who could get a favorable jury verdict first. Covenant removed that system of direct action, said it must be by assignment. Mecosta decided the collateral estoppel res judicata issue in the assignment context. What happens if the injured party gets no cause? Is that binding on the provider who has a right by assignment? The Supreme Court said no. But the interesting thing is we now have no fault reforms that reinstitute the direct action remedies of a medical provider. So are those old cases pre-Covenant going to still be applicable to the new statute? Or are we going to have to go through this battle all over again and get some other rules? So we're going to have this 2-year period where Mecosta controls, and then once the direct action remedy is reintroduced, are we going to go back to the pre-Covenant days? That's an open question. That's another issue the Supreme Court's going to have to resolve it at some point. But getting to the question Eric did ask, there were 2 Court of Appeals opinions issued on December 2nd, identical panels of Court of Appeals judges, and these relate to wrongful death damages available when the decedent in a medical malpractice case is a minor child. In the good old days, there was a case called Baker versus Slack. It was controlling. In that case, the loss of economic damages in a wrongful death case was focused on what did the decedent provide to his or her dependents, not what did that decedent actually earn. So that distinction doesn't seem that important, but it is when you have a minor child. So in Baker versus Slack, I believe the decedent was in her late 60s. She passed away. She had no dependents. She wasn't providing financial support to anybody. And the Michigan Supreme Court said there's no loss of financial support available in this circumstance under the Wrongful Death Act. The Wrongful Death Act was later amended to include the grand total of one word, including. And by saying wrongful death damages include the following, there was a 2016 decision in a governmental immunity case known as the Denny decision. It was 7 years ago now. And in that case, the court changed it was a Court of Appeals decision, didn't cite Baker versus Slack, the Supreme Court case, and said that there would be economic damages available to the decedent's estate, regardless of financial support. And it focused more on what that decedent would have earned had the decedent not been killed. So we had Denny on the books for 6 years until December 2nd, 2022, where the Court of Appeals decided 2 more wrongful death cases. These were medical malpractice cases. One decedent was a prematurely born baby, and the other one was a 13-year-old child. Both died as a result of alleged medical malpractice. And the question is, what happens for economic loss when the decedent's a child? Does the decedent's estate get loss of financial support? Well, you don't really know who a premature baby's dependents might be in the future, or even a 13-year-old's dependents might be in the future. And in these 2 cases, December 2nd, both published, the Court of Appeals reaffirmed the Denny rule and said that Baker versus Slack is no longer controlling because the statute's been amended to add the word including. And as a result of those 2 decisions, a deceased child can make a claim for economic damages for the loss of income that the child would have earned. Now, these 2 cases weren't consolidated, I don't think, but they present 2 different fact patterns. You had a premature baby, and then you had a 13-year-old. Now, let's say this, it feels very creepy to be talking in such callous terms about these things. These are both just horrific cases. So the way the Court of Appeals resolved the economic loss issue in those 2 cases, in one opinion, the court said, a premature baby, we have no idea what that baby's life would have looked like had the baby survived. So we can't even project economic damages for a deceased premature baby. It would be speculative, kind of Michigan's law, and speculative damages are not recoverable. In the other case, however, it was a 13-year-old who I believe was in 8th grade at the time, and the court said, we think a 13-year-old has enough of a personality, hopes, dreams, goals, desires, those kinds of things, where a jury could say, we think this 13-year-old would have earned X amount of dollars based on a particular career that 13-year-old would have pursued had the 13-year-old not died. Obviously, this is going to be a major issue that the Supreme Court will have to weigh, and the Court of Appeals opinions said as much. They said this is not going to be easy. We can't say how old is old enough to allow economic loss damages. Some 13-year-olds are very immature. Some 45-year-olds are very immature. And it's going to require a list of factors, and it's just going to be this kind of case within a case on the economic damages issue now, where if the decedent's parents were professional basketball players, does the decedent, because he was tall, going to be a professional basketball player? If the parents had a low level of education, or is that child going to have less likely high income earning in her future? I don't know exactly how the Supreme Court's going to weigh in. I believe they should weigh in at some way. The legislature should weigh in, if anything. But that's going to be a major issue. I know that the initial read of those 2 decisions are that they're medical malpractice decisions. I don't read them that way. I think they're wrongful death decisions. I think that's going to be in all contexts, not just medical malpractice.
Very interesting to see what is coming. So look at that. I was early today, which if you know me is a big deal, and we're done at exactly 1 o'clock, which pretty much makes us amazing. Does anybody have any questions that they want to pop in the chat? If not, we are some of the friendliest people you'll meet other than Chad Engelhardt. And so you are welcome to send us an email if you have any questions about anything that we talked about today, or you want a further insight, or you need some appeals help. We are always more than happy to help. So thank you everyone for participating. We very much appreciate it. And we hope you learned something that you didn't know before. Thank you.
Thanks,
Thank you.
everybody.